Welcome back, everybody, and thank you for enduring with us. We're reaching the end of the Congress, but we hope coffee gave you energy for this last round of presentations. Today we have the second panel of scientific communications, and as you can see, we have a very well-equipped table in order to discuss interdisciplinary approach to metaverse issues. And we're going to start with Jaime Olmedo, who is a predoctoral researcher at the University of Alicante at the LEA project. And without further ado, Jaime, the floor is yours.
Thank you very much. Good morning, and thanks for the opportunity to present this paper at this Congress. That is an international reference on metaverse topic. My presentation focuses on the industrial metaverse and more specifically on the role that data spaces can play as its legal and technical infrastructure. So the central claim of the paper is that data spaces are not just a useful technical option. Rather, they could be understood as the framework that makes industrial metaverse legally workable in practice. So, especially in terms of trust, security, compliance, interoperability, liability, and fair use of data-driven assets. So, let me summarize this argument in 3 points. So the first one is that industrial metaverse is a highly intensive data and multi-party environment. What does it mean? So it depends on digital twins, connected machines, immersive collaboration, and constant flow of data across organizations. Second, the main difficulty for me is not simply the existence or absence of legal rules. As some panels says later, the European Union already has a dense legal regulatory framework, so the real problem to me is how to make those rules operational in real industrial ecosystems. And the third, this is where data spaces become important. These instruments or these infrastructure provide a structured environment in which governance rules, technical standards, usage policies, and traceability mechanisms can work together. So, in other words, they have to translate legal requirements into enforceable practices. So, what exactly changes in the industrial metaverse? To understand why this question matters, we first need to understand what changes in industrial metaverse compared with earlier digital environments. So the first shift is the rise of real-time digital twins. These digital twins are not static models, but they are continuously adapted representation of processes, systems, or even physical assets. So the second shift is that industrial interaction becomes inherently multi-party. Manufacturers, suppliers, software providers, maintenance operators, cloud services, and sometimes public actors all become part of the same operational ecosystem. And the third shift is the growing role of AI automated or assisted decisions. Once these decisions based on shared data begins to affect physical systems, legal questions such as accountability, causation, and become much more difficult. So this leads to another practical question: why do we need data spaces? In practice, industrial metaverse, ecosystems face a recurring set of problems: fragmented contracts, unclear roles, lack of trust between participants, high compliance cost, and the fear that sharing data might expose trade secrets or valuable digital assets. So there is also here a market structure dimension. If this infrastructure remains proprietary, smaller firms risk dependency on platforms, which is precisely what the EU regulatory framework, including the Digital Markets Act, aims to prevent. So data spaces addresses this by design. Their federated and interoperable infrastructure reduce lock-in and makes participants viable for wider range of actors, including SMEs or smaller players. So this connects to a key concept in the paper that is called competition, that competitors compete on traceability and safety of the data, but only because the architecture itself prevents that cooperation from becoming anti-competitive information exchange. So data spaces are relevant because addresses all these problems structurally through shared governance, interoperability, policy-based usage, control, and auditability. So why this an emergency in European Union context? At the European Union level, these discussions take place within an increasingly dense regulatory framework. We have the the Data Act that addresses use to access to and use of data generated by related connected services. Connected products and related services. The AI Act that adds another layer, especially when digital twins incorporates AI that might qualify as high-grade systems, and also the Red.es Product Liability Directive that extends logic liability to connected to digital components, and the Cyber Resilience Act that adds cyber security requirements for products with digital elements. So, in my opinion, the real question is implementation. These rules exist, but industrial actors need an infrastructure capable of translating them into real-world data practices. So, this is the function that this paper attributes to data spaces. So, how a data space works concretely, I'll try to explain in a simplified way. At one end, we have participants, manufacturers, suppliers, service providers, machine operators, and other relevant actors. Then we have connectors. There are no mere technical gateways. There are the point where identity, contract negotiation, access control, and policy enforcement can be operationalized. And then we have governance services, rule books, interoperability profiles, trust mechanisms, and shared organizational rules. So finally, we have logging and clearing functions, which make data transaction traceable and also auditable. And also identity is a transversal element at this architecture in the European context. We have emerging frameworks like EUDI Wallet, as they have mentioned before, but illustrate how participants, services, and devices can be verified without centralizing control. EUDI Wallet is for humans, but there are another systems that can allow identify AI systems or machines. So the key idea here is that the law does not remain outside the architecture. In a mature data space, governance rules and technical controls converge. So how do we translate these norms into enforcement? A large part of the paper, I wasn't changing the slides. A large part of the paper requires a move from reactive compliance to compliance by design. So rule books define roles, responsibility, and condition of participants. Interoperability ensures that different actors and systems can actually communicate within a common framework. In this sense, worth mentioning the Article 33 and 35 of the Data Act that are particularly relevant because it makes interoperability a legal requirement for data sharing environment. And also there are a technical enforcement layer. Here, machine-readable policies, such as those expressed in ODLR language, become very important. So they can define who might access the data, for what purpose, for how long, and whether onward sharing is allowed. This means that all these legal restrictions do not remain purely declaratory. They can be expressed, enforced, and law through the architecture itself. So this set up one of the central claims of the paper, that the issue here is not only that who owns the industrial data or digital assets. So the prior question is whether uses of those assets can be even made visible and attributable in the first place. So traditional IP and industrial property mechanism presuppose that the act of exploitation can be identified. But in the industrial metaverse, those acts are often automated, distributed, recurrent, and even embedded in complex systems. So the paper argues that before we can effectively discuss ownership, control, and remuneration, we need an infrastructure capable of making those acts of use visible, recordable, and attributable. And how can data space contribute to this? In 4 steps. The first one, ingesting and annotating the asset with metadata and usage conditions. The second one is expressing the policies through machine-readable rules. The third one is enforcing and logging the relevant uses. And the fourth is using those records to support auditing and possibly proportional remuneration models. So the contribution here is that the data spaces do not create a new IP right. Rather, they can make informants and evidence more realistic in a complex digital environment. So this leads to another relevant question, that is liability and traceability and governance. So one of the biggest problems in the industrial metaverse is that linear causation begins to dissolve. So, for example, an incident might involve data generated by one actor, processed by another actor's algorithm, integrated into a third party's digital twin, and maybe finally causing physical damage to a fourth actor asset. So this is precisely where data spaces become really valuable. The architecture generates an audit trail that implies or allows to know who requested which data, under which policy, at what moment, and with what result. Result in the sense of if the transaction was completely successful. So this, for me, generates a first-order legal asset, both for proving causation and also for demonstrating due diligence. But traceability alone is not enough. It must be combined with governance. So data spaces support a multi-level model that distributes responsibility ex ante among 4 main roles. The first one is the governance authority, the second, the ecosystem operator, the data provider, and also the data consumer. So this matters because the responsibility in these environments cannot be left completely to expose reconstruction. So it has to be partially organized in advance. Why? Because due to the complex of this context, it's almost impossible to reconstruct all the factual chain of the events that have occurred. So in the Spanish context, inscription in the trust list does not create an automatic legal presumption, but it may still operate as a qualified evidence of technical and organizational diligence. Finally, there is also a private law dimension that is worth highlighting, maybe not by listing the instrument, but also pointing to what data spaces can contribute in this context. So applying ROM 1, ROM 2, Brussels 1bis to a distributed industrial ecosystem requires identifying connecting factors, where the data was originated, where it was processed, and which node introduced a defect. So with a structured traceability, the determination without this structured traceability, that determination is very difficult. So the audit trail tries to solve this problem by documenting the origin, processing, and transmission of each datum and identifying the operator of each node. So it makes conflict of law rules actually applicable in environments where they would otherwise struggle to function. So and even where the European Union rules no longer govern, international arbitration also is an important instrument here under the New York Convention or something. Yes, and again, the data space evidentiary record is what makes arbitral proceedings here viable. So this is not only a compliance issue, it is also a major question of conflict of law, forum design, and ex-ante governance. And I would say maybe it is one of the most open research agendas in this field right now, how to develop this structure, not only technical, but also governance and legal. And is this only theoretical? In my opinion, no. This paper also includes some examples of real implementation of those data spaces. The clearest example, is the Catena X. That is, it shows how a federated data space logic can support battery passports, traceability, and shared industrial coordination across supply chains. Manufacturing X demonstrates that this is not only limited to automotive sector, it is an effort to generalize this model to other sectors, and the Spanish content is also relevant. La norma UNE 8725, la lista de confianza y el kit de espacio de datos, and projects such as LEADE show that Spain is beginning to build its own governance and implementation layer for data spaces. So the paper's thesis is supported by real industrial and institutional developments. These are not maybe fully mature projects yet, but I think it shows the direction that we need to take. So let me conclude. I have time now. Oh, sorry. Let me conclude with 5 takeaways. First, the industrial metaverse is fundamentally a governance problem for multi-party flows. Second, the European Union already provides a dense legal framework, but the real challenge is make that framework operational. Third, data spaces are important because they combine governance, interoperability, enforceability, and traceability. For the relevance go beyond the access to data. They also improve accountability, evidence, liability management, and the protection of industrial valuable assets. And fifth, the next stage of the debate should focus, in my opinion, less of legal on abstract legal reforms and more on concrete architecture, standards, and governance models that can actually work in practice. So, to finish, sorry. If the industrial metaverse want to become a real industrial infrastructure rather than a speculative concept, it needs a trustworthy legal and technical foundation. And my argument is that data spaces are the strongest candidate for that role nowadays. Thank you very much.
Well, thank you very much, Jaime, for such a comprehensive overview on the different layers of data spaces. I agree with you that if deployed properly, data spaces do have the power to become the backbone, not only of the metaverse, but of many frontier technologies, which probably explains the impulse that the European Union has been trying to give to these spaces. Again, from theory to practice, there's a gap, so let's see how long it actually takes us to get there, but the bases are being set. And so next we have with us Oscar Verdoire. He's also a long-standing friend of the chair. He was with us in the second Congress last year. And now we're lucky enough to have him doing a research stay with us for some months. So he's going to be speaking about copyright governance of user-generated content from physical media to the metaverse. So Oscar, please enlighten us.
All right, just making sure. Can you all hear me? Whoa, okay, that's a little louder than I thought. Hello. Sorry about that. Hello, everyone. It's an absolute pleasure to be here today. I just quickly wanted to thank the chair for accepting my proposal, for having me here, and letting to speak today about my research, or at least, well, some of it, so to speak. There's been a lot of very interesting presentations here today, and I really hope you'll count mine among them. So today, as the title so lovingly shows, I'll be discussing copyright governance of user-generated content from physical media to the metaverse, and specifically how we need to look at how past governance has handled conflicts in this area to see how some change in copyright law might be necessary to accommodate the metaverse or future technological developments in a similar vein. Now, okay, that works. Now you'll have to bear with me just a little bit before discussing the metaverse, as I'd like to get some core elements out of the way to set the scene, so to speak, so we're all on the same page. First, what is user-generated content? People from last year will recognize this slide. Well, content, first of all, very obviously, is any creative media that we, as consumers or users, enjoy that is created for us. This includes stories and books, films, YouTube videos, songs, video games, and so much more. These works are created by those we traditionally call authors, and under copyright law are known as rights holders most of the time. User-generated content, then, is any content created by those who would traditionally be considered users. That means you, me, anyone else, really. Such content is also known as amateur content, or secondary works, and would include fan fiction, social media posts, memes, video game mods, all made by users or consumers of the original product. Now, the main goal of copyright has always been to protect authors' rights to object to any unauthorized reproduction, distribution, or modification of their works to secure their economic exploitation thereof, thereby protecting their interests in the work and their creative expression. However, it has always needed to be balanced carefully so that others can make use of these works in the right circumstances. Again, the idea is to protect creative expression, not ideas, which is why concepts like, I don't know, cat-like aliens aren't protected the same way. These rights are related to reproduction, distribution, and modification, and are typically referred to as economic rights. And these are globally protected under copyright law in most jurisdictions. Some jurisdictions, however, also protect certain moral rights in a work related to the reputation of the author, the attribution of authorship, and the right to object against any distortion of the work, which is a lot more flexible as a term. If interpreted strictly, these provide a much more stringent protection of works to authors. To balance copyright law with what I like to call user rights in this context, several exceptions to copyright are provided. For example, parodies, reviews, and critiques are protected within the EU and the US alike, and the US also allows an additional broad exception under fair use. In essence, these allow other authors and us as consumers to use certain parts of a creative work within specific contexts. Now, there are a lot of different forms of user-generated content, and for this paper specifically, I narrowed down the scope to physical media and UGC inspired by physical media. I should have mentioned earlier, UGC is short for user-generated content, which I define here as creative works that can be subject to copyright expressed in a tangible medium. These are tangible creative works that you can physically touch. On the slide, I have a few examples. For example, published books, 3D printed miniatures, which can also just be inspired by existing franchises, or even fan-made encyclopedias based on existing works, though the encyclopedia would typically fall under user-generated content rather than its own copyright particularly. In 2010, Rachel Stroud divided fan fiction into two categories, referential and participatory. Referential works, as their name implies, reference the original material and offer guidance on understanding it, like with a fan-made encyclopedia or a wiki. It's a guide. Participatory works, on the other hand, use the original work to make something new, reusing characters, settings, rules, and more. This is what we typically think of when we hear fan fiction. When Stroud applied this categorization, she applied it exclusively to fan fiction. And I would argue, however, that it could include any or all types of user-generated content. An online wiki is very much referential work, while a fan animation on YouTube would be a participatory work. Why this distinction matters is that they are treated somewhat differently under law and by authors of the original works. Referential works are typically purely informational, and are much more likely to fall under relevant copyright exceptions because of this. That does not mean, however, that they are never considered infringing, as in Warner Bros. VRDR Books, a case concerning a Harry Potter fan encyclopedia. On the other hand, participatory works necessarily use and expand upon elements of the original, thereby being more likely to infringe, as some of the original author's creative expression is borrowed. What ultimately matters, however, is that what the author is willing to tolerate. Some fanfiction communities, for example, have thrived across many years, like the Harry Potter fandom, whose fanfiction J.K. Rowling has continued to support. Others, like Anne Rice, instead take a stand against UGC, threatening their fans with lawsuits at every turn. What ultimately matters is what legal scholar Tim Wu has called tolerated use. In other words, what an author is willing to tolerate before they start suing fans. What they tolerate, however, is not set in stone. This isn't a legal measure of tolerance, but a choice not to pursue legal action. This places businesses based on UGC, which are sometimes allowed to exist due to the continued tolerance thereof, at risk, especially when rights holders suddenly change their mind, as they can sometimes do. On this slide, I've posted a few headlines from, well, relatively recent incidents where a company owning the rights to a brand decided to change what they would allow as UGC. These incidents involved Wizards of the Coast and the Dungeons & Dragons open game license, and Games Workshop and their Warhammer fan content policy. In both examples, the rights holders previously tolerated much fan content, even encouraging it within their policies. However, both companies changed their minds and decided to start limiting how much they would allow in user content. Users, in response, protested with their wallets and their attention, leaving for greener pastures. For example, one title specifically here, D&D's OGL controversy turbocharges sales of virtually every competitor in the space. So that's a way that users have protested. They have a certain power in that regard. This specifically for Wizards of the Coast and D&D. They backpedaled so hard as a result of this backlash that D&D is currently now licensed under a Creative Commons license, which, for those who know IP in the room, allows much freer use of the IP than before. In contrast, Games Workshop still holds strong and has maintained their policy at the detriment of much previously popular UGC, likely made possible due to the pseudo-monopoly they hold over the tabletop wargaming space. What is important to note here is that users can have some impact. They can protest certain changes. But depending on the position of the rights holders within the market or the hobby, their complaints may or may not just be ineffective. Now, you're all sitting here for some time now and listening to me talk about UGC and physical media. How does this all relate to the metaverse? While the example specifically may seem to have little to do with the metaverse at first, what matters are the lessons that we learn from such conflicts surrounding user-generated content and copyright, and how these conflicts were, or in some cases weren't, resolved. Copyright was originally made for physical media, books specifically. It has since evolved to cover new types of media, including websites, blog articles, video games, software. And it is in how this regulation has evolved, or in some cases failed to evolve, that merits discussion in the case of the metaverse, which is meant to be a new frontier for user expression in creativity. It goes beyond this evolution as well. Ownership and management of the metaverse beyond the scope of copyright law is ultimately what will likely break the presence, make or break the presence of UGC on the platform, or even potentially the platform itself. Now, over time, the roles of user and creator have converged, and we can see that this change has accelerated across different mediums. Formatting wasn't right there, whoops. While we can see this has especially happened on the internet, physical media is no exception. The D&D example is from 2023. Copyright, however, has not changed significantly to adapt to these changes, merely providing a few clarifications on existing exceptions and how they might apply in a digital environment, or for different regulation for intermediary liability. The metaverse, on the other hand, is meant to provide a new and groundbreaking environment for user interaction, self-expression, and creativity. This is true no matter which definition of the metaverse you believe in, be it the metaverse that is already here with games like Minecraft or Roblox, or Zuckerberg's pipe dream of a Matrix-like metaverse. As such, with self-expression and creativity playing a major role through avatars or other potential forms of UGC that we don't even know about yet, the roles of user and creator will likely to continue to converge further until, in some contexts, it might be impossible to differentiate the two. Yet, while the roles change, the law hasn't necessarily followed suit. It may, therefore, be time for some adaptations or revisions to copyright law to prepare for or adapt for the metaverse or for modern content more generally. As shown earlier, authors have always had more power than just what the law grants them. They can rely on a cease and desist order before taking anything to trial, effectively threatening fans with legal action. If working with a larger publisher or a company, they can have access to much greater support than UGC creators typically would, both legally and financially. Even before sending a cease and desist letter, they can use legal support to draft an airtight fan consent policy, making clear the extent to which they will tolerate, or not, fan works. If they want to change this policy, the notice can vary. On many platforms today, there's a certain notice period that is expected for these changes. When it comes to a much more informal policy, however, that notice period might not exist at all, as the interpretation of their policy is ultimately up to them when they finally decide to act upon their rights under copyright law. Such policies and documents place rights holders in a very strong position. Most users would back off, especially when they see takedown notices that boil down to, "Stop copying my stuff, or I'll sue you." Despite them potentially having made legitimate use of the original work. In the metaverse, it is unlikely that copyright literacy will suddenly increase, or that the resources made available to user creators will suddenly increase as well. Documents explaining limitations to copyright and tolerated uses like the terms of service or the EULA are often skimmed over. We've had this discussion at the conference already. Most people just click accept and move on and want to access the content instead of having to read through all the details. And this is unlikely to change in the metaverse, obviously. But it is important for the law to consider when moving forward, as it so rarely has in the past, and potentially place even greater safeguards for secondary creators. Will the metaverse support enforcement of copyright? How will the metaverse push the boundaries of UGC? Are the present systems for UGC regulation fit for purpose on the metaverse? These are the questions that need considering and potentially and hopefully answering as we build the metaverse. Now, copyright law has traditionally allowed for exceptions that have allowed for the creation of secondary works, though rights holders ultimately remain the primary beneficiaries of copyright law. Consumers have always had a secondary role and have not been the primary focus. Newer platforms and forms of media, however, have encouraged more creation by users, and these users are playing an increasingly more active role. Look at YouTube, for example. Everything on there is made by users. YouTube itself remains the background. Now, you could argue this is because they're an intermediary, still. Or alternatively, look at games like Skyrim. Skyrim was released in 2011, and it is currently still relevant over a decade after its release, thanks to mods made by users. However, despite this increased role, users see no additional protection under the law and rely on authors' tolerance to continue creating. If the metaverse follows suit and continues present approaches to UGC regulation, users will remain in a significantly weaker position than authors. It is by looking at the origins of how copyright law and the content it was meant to regulate that we can compare it to what media on the metaverse will become, and how the law may need to change as a result. One example is jurisdiction. The online nature of the metaverse puts copyright cases at risk of legal tourism, which again runs in favor of rights holders, as they can shop for the best country to settle their lawsuit in that will give them the best possible ruling or the most strict response to UGC. And users, again, in this context, are less financially and legally supported and might not be able to afford or realistically commit to a lawsuit overseas, and instead must submit or settle. To summarize everything so far, in the metaverse, no matter its form, there will be more of everything we've already seen. More interactivity, more users, more creativity, more copyright infringement. It is, however, unlikely that users would retain the same limited power to protest change that they have had so far, and it is likely that authors using both legal and extra-legal means would be in a significantly more powerful position. And that is just assuming the metaverse works like the internet. If the metaverse is privately run, then it places a third party within a powerful position as well, though likely as an intermediary within copyright law. As a lot of this remains unclear, it suggests that some reform may be necessary, as modern law continues to lag behind a lot of technological developments. It'd be nice to preempt for a change. We need to take lessons from what exists and technically works and see what we can change. If the metaverse amplifies creation at scale, a system based on tolerated use, as we've used so far, is unlikely to remain sustainable going forward. And that concludes my presentation. Thank you so much for listening.
Well, thank you very much, Oscar, for continuing to illustrate also in such an engaging and clear way, I must say. The tensions arising from the lack of adaptation and the lack of update of the present legal frameworks. Next with us, we have Kęstutis Mosakas, philosophy researcher at the Vytautas Magnus University, and continuing a little bit with the ethical, philosophical approach that we were having yesterday in the afternoon, he will be discussing about human moral responsibilities in the metaverse, a hybrid approach to the moral consideration of virtual entities. So please, the floor is almost yours.
So, thank you for the introduction. Okay, that works fine. So it's great to be here. My presentation is titled Human Moral Responsibilities in the Metaverse, Hybrid Approach to the Moral Consideration of Virtual Entities. And let me start right away with a few clarifications. First, I will focus on ethical issues rather than legal ones, such as what's morally permissible and impermissible in the metaverse. More specifically, I will be talking about the ethical limits on how users may interact with the virtual environments and treat entities present in them. Of course, these issues may have legal implications as well, but I won't directly address them here. Additionally, I will assume a more developed metaverse than what we currently have. Right now, the VR spaces are still fragmented. The embodiment and immersive experiences are limited. Economies are relatively weak, and AI agency is minimal. But over the coming decades, we can expect greater immersion, more integration of infrastructure and economies, and increasingly sophisticated AI agents as well, potentially with memory, personality simulation, and even long-term goals. Now, even if this remains speculative, it's important to consider the ethical issues in advance so that regulation does not lag too far behind technological development. Finally, I would like to mention that my approach is informed by my research in robot ethics. According to Peter Asaro, robot ethics consists of three subfields: machine morality, the ethics of design and use of robots, and the ethics of how humans should treat robots themselves. My focus is on the third question: how machines and artificial entities matter as objects of human action. One outcome of my research was what I call a hybrid approach to the moral consideration of artificial entities. So I would like to briefly present the framework and then draw out some of its implications for the virtual worlds. So the basic idea is that different kinds of entities can count morally in different ways. I distinguish three categories which indicate how and why a particular entity is morally important, what is the source of its moral worth, and what kind of duties it is owed. It would be hard to cover the framework in detail now, so I would just like to present the main idea. So first, there are things that matter only indirectly and instrumentally, like personal possessions, resources, infrastructure, and similar. Second, there are things and entities that warrant a form of moral respect in virtue of the special relationships in which they stand. Some examples could be cultural and historical artifacts, national symbols, and even human remains, among others. And third, there are conscious beings whose lives can go well or badly for them, such as most human beings and some non-human animals. So the approach posits an indirect dimension of moral consideration and two direct ones. I refer to it as a hybrid approach because it treats both intrinsic properties and extrinsic relationships as morally relevant. The third category assumes that consciousness is a morally relevant property, whereas the second one assumes that some objects matter intrinsically just because of the special relationships in which they stand. So the framework is both properties and relations based. Now, let me say something about each category in the context of the metaverse, starting with the idea of indirect moral consideration. This is one of the most relevant domains at the moment. When you are represented by an avatar in VR, other users can't harm you physically. But virtual environments generate their own harms and risks. Here, one key factor is the virtual infrastructure itself, because it mediates the interactions between agents present in it. In a sense, one could say that ethics is already embedded in the way the virtual environment is built, depending on what actions are made possible, what constraints exist, and what behaviors are incentivized. So in this way, the structure of the environment already influences how people might treat each other, even before any specific actions take place. Another closely related issue is character formation. When people spend time in virtual environments, they often repeat certain patterns of behavior. Over time, these patterns can shape their habits, attitudes, and expectations about how to treat others, and ultimately carry over into other parts of life. And that is why long-term exposure to certain types of virtual interaction can have indirect moral effects. Finally, virtual goods or resources matter instrumentally. This makes transactional harms possible in VR, such as fraud, theft of virtual property, market manipulation, unfair exchanges, and others. This is not an exhaustive list. One could likely come up with more examples. But what I want to focus on is the underlying rationale. Protecting users, stabilizing systems, managing behavioral spillover effects. These are all important and well-recognized points. But I would argue that philosophically they are the least interesting. Ethically, they all follow a familiar pattern. They focus on human users, identify the ways in which users' interests can be affected, and then they aim to prevent or mitigate resulting harms. However, as VR technologies develop, additional dimension to the problem might emerge. And this brings us to the second category. This might be more controversial, but I want to suggest that socially interactive, human-like virtual agents could have intrinsic moral value. In the context of robot ethics, philosopher of technology Sven Nyholm argues that respect for humanity also entails respect for apparent humanity in robots. Specifically, Nyholm gives an example of control, stating that if there were an extremely human-like robot, exerting total control over it would symbolically represent domination over a person. And that is a representation that seems morally problematic in itself. As another closely related issue, consider sex robots and the possibility of their abuse. By abuse, I mean actions like causing physical damage ordering robots to perform degrading or humiliating acts, treating them as slaves, and so forth. In extreme cases, consider the possibility of child sex robots or robots with specific racial and gender features made to satisfy human cruelty instincts, sexual fantasies, or vanity, like in the Westworld series. Maybe such robots shouldn't be built in the first place. But my point is that if such robots existed, and even if they weren't conscious, they would still be representations of human beings, sometimes of specific groups of people, and treating them in degrading ways would arguably violate norms of respect. The same reasoning applies to virtual environments, because socially interactive, human-like agents in the metaverse can function as representations of persons, and therefore we shouldn't be able to treat them however we please. Now let me briefly consider two objections to the view I just outlined. The first one is that the wrongness of robot abuse can be fully accounted for in terms of indirect harm. For example, their negative effects on users' character, which would lead to further negative consequences outside the VR. In response, I don't deny that such downstream effects exist, but I question whether they exhaust what is morally problematic in this case. An interesting analogy here could be dead bodies, because a dead body itself doesn't care how it's treated, but it remains symbolically connected to the person who once lived and to humanity in general. If we really didn't owe moral respect to dead bodies, it would follow that it's okay to abuse them as long as no one else is affected. For example, if no one ever finds out. But that seems morally troubling, and symbolic considerations help explain why, while indirect harms do not. The second objection appeals to video games. If virtual agents matter on symbolic grounds, wouldn't that imply that game characters matter as well, which seems morally over-inclusive? I have two responses. The first is that the metaverse is disanalogous to video games in important ways. Game characters are typically scripted, limited, and isolated from real social norms. The metaverse, on the other hand, is a shared social space that could eventually contain persistent, interactive, and seemingly autonomous agents. Second, I would say the objection can be flipped on its head. Not even in video games all representations are morally permissible. As illustrated by the so-called gamer's dilemma, while virtual murder is common and generally tolerated in games, particularly grotesque acts like sexual abuse of children are not. So I would say that symbolic constraints already operate in virtual contexts and may become more significant in immersive environments. Now let's turn to the third and final moral category. Could VR entities eventually become conscious beings with their own subjective welfare? Consider again a recent development in robot ethics. In 2024, a white paper authored by 10 prominent researchers in philosophy, cognitive science, and AI ethics was released. The main contention of the paper is that the possibility of AI systems becoming conscious and possessing subjective welfare in the near future, for example by 2035, is non-negligible, and that AI companies and other actors should acknowledge this and take precautionary measures. How do the authors reach this conclusion? Well, they do so by drawing heavily on our current neuroscientific theories, with the upshot being that current frameworks are highly inconclusive regarding artificial consciousness. In ethics, uncertainty of this sort typically calls for what is known as the precautionary principle. If we are uncertain about the presence of consciousness in some AI systems, we should treat these systems as though they are conscious, because otherwise we risk mistakenly harming them. Following the authors of the paper, in the context of VR, I would frame the issue as follows. Whether virtual agents can become conscious is not an issue that we are likely to resolve anytime soon. The more relevant question is whether there could be reasonable uncertainty about their consciousness. For example, if they had virtual brains as complex as ours. And the answer is yes, there could be. For example, David Chalmers and other functionalists about the mind have argued that if a system with a biological brain is conscious, then a system with a perfect simulation of that brain will be conscious in much the same way. We don't need to agree with this view. It's enough if we grant that it is at least a serious and a non-negligible possibility, given that the moral stakes could be very high. And if that's right, then the existence of virtual agents with potential conscious welfare ultimately depends on whether future technological developments can produce virtual entities of such great complexity. So in conclusion, who and what matters in the metaverse? Starting with the first category, virtual goods, infrastructure, and modes of interaction matter indirectly. One thing we see here is a limitation of my original framework. It was framed in terms of things that matter indirectly, but in virtual environments, the idea of mediation becomes central. How design shapes users' interactions, their long-term habits, and their security. So this category may need some expansion or further specification in the context of the metaverse. The second category, sufficiently interactive, autonomous, and human-like virtual agents may matter directly in virtue of their symbolic and relational significance. How we treat them raises questions about respect for human likeness and shared social norms. This also forces us to ask which kinds of representations are morally problematic and to what extent. At the same time, these agents can matter indirectly as well through their effects on users' behavior and attitudes. One practical advantage here is that unlike with physical robots, harmful interactions in virtual environments may be easier to regulate through design. But that doesn't make the issue any less important. And finally, the third category, virtual agents with the potential for morally relevant welfare. While this remains uncertain, it is not something we can simply dismiss. If future systems reach sufficient levels of complexity, then given the potential moral stakes, there may be reason to adopt precautionary measures, such as design constraints, safeguards, or even prohibitions on certain types of agents. Thank you for your attention.
Well, thank you very much, Kęstutis, although I don't know if I should thank you because I'm leaving this panel slightly way more concerned about the moral malfunctions we may experience in the metaverse. But not really. I think that your perspective and the philosophical reflection is essential, and thank you for bringing us today. And last but certainly not least, we have Jacopo Piemonte. He's not only a long-standing colleague of the chair, but a long-standing friend. And we are very happy to have him us with here today. And he's a PhD candidate at the Cyber and Data Security Lab from the Vrije Universiteit, Brussel. And he will be speaking about neurotechnologies in the metaverse and EU law. So, Jacopo, please, whenever you're ready, you can go.
Okay, thank you very much. Good morning, everyone. Thank you very much for inviting me in Alicante, in beautiful Alicante, first of all. And also congratulations on the organization of this fantastic conference. I learned a lot, and let's say there were many topics which intertwined, overlapped with my today presentation. So sorry about that. But I tried to, let's say, as the last one, to be a little bit more engaging as much as I can, and to add some food for thought for everybody. So let's start by introducing what is the elephant in the room for my research, that is to say the brain. As we all know, it's probably the most powerful organ of our body. And it is well known that its potentialities are largely unexplored to a certain extent, meaning that in the future we hope that we might study and map it even more well in order to understand how, let's say, improve the conditions of the humankind. But the steps which were taken by science are already quite impressive, and one of these let's say, improvements are the neurotechnologies, which are an incredibly good technology, so to say, for the human being. And in this case, we have devices which are connected to the brain. They read signal brains, electrically signal brains, which are released instead by our brain. And in this case, for example, in case we have paralyzed people, they are in a position, these technologies, to intercept the signal, bypass the damaged part of the body, and have the possibility to convey the message to certain devices, for example, to move robotic arms and so on and so forth. So this is quite telling, and it has a direct relevance for what we are discussing in this conference, that is to say the metaverse. You would understand that if we have neurotechnologies that are that powerful, those can be a game changer in the metaverse. For sure, for the more simple technologies in the metaverse right now, we still need a keyboard in order to access the virtual world. But if we move forward with the neurotechnologies, then we will be in a position, in a way, to have the users enter into the metaverse using just their thought, so to say, without the need even to move their hands. So this would be kind of a challenge. It is definitely coming. But we have to understand to which extent this technology can be impactful. So we have the invasive one, and in this case, we have devices which are inserted directly in the brain. And this, of course, raises some concerns, given their invasiveness. And they have a great signal, so they have a great potential. On the other hand, correctly, all the legal frameworks are mapping those technologies as quite scaring, so to say, so that rightly and correctly they are submitted to heavy medical regulations. And in Europe, for example, we have the medical device regulation. So, of course, there are then, let's say, technologies which are not invasive, and those ones basically are just grounded on the fact that we can have helmets with electrodes, which are, let's say, placed just on the surface of the scalp of the human brain. In this case, not being invasive, they in any case can reach more or less the same result with a little bit less of efficiency. But you would understand that those technology, not being that invasive, can be very much appealing for the companies, given that, of course, a company may argue that they are not medical devices because they can be used for recreational activities. They don't have to be submitted to high compliance due to the medical regulations, and there are softer pieces of legislation that can be used and can, let's say, be used to regulate them. Of course, today we will discuss about these technologies, the non-invasive one, but we have to understand that beside not being invasive, of course, they can generate huge issues for, let's say, the humankind in a way. So first of all, we have already heard the term of mental privacy. Of course, if those signals in a way intercept the human thoughts, and then, for example, by machine learning or artificial intelligence can understand our behavior and so on and so forth, then those technologies have the access of our most intimate thoughts. So the mental privacy there is really at danger. More than that, when we move forward a little bit with the technology, then we will have kind of helmets which can be embedded directly in the visors in the metaverse, and in that case, some external subjects may try to hack our brain and may try to manipulate our behavior. So let's just think to the neuromarketing, for example, which is quite a soft example, but when we can go and make an example which impacts even more on the brain and on the human condition. Finally, it is a matter of fact that if those technologies are working that well, so if basically I can move myself through the thought in the metaverse, then I might be empowered in that reality. I might feel to be a superhero there. And the problem is that when you take off your helmet, when you take off your visor, you are faced with the reality, which could be, let's say, much more interesting than the metaverse. And you might have issues, let's say, to your psychological continuity, so to say. So it is interesting to say, and actually my research question goes exactly to see whether the European Union legislation would be enough in a way and would pose enough safeguards to protect the rights which I just mentioned. And also here we have kind of a decision that will have to be taken in the real near future. On the necessity to introduce into the European legal union the so-called neuro rights. Certain nations like Chile have already gone down that direction, that is to say that they have inserted in their constitution such rights such as the mental privacy, psychological continuity, and the ones which I remembered before. But on the other hand, we have to see that the, let's say, trend seems to be that let's say, many authors and services which were released also by the European institution seems to uphold the fact that those rights would be already embodied in the fundamental rights that the European Union has embraced. So basically, neuro rights would not be necessary, and we should cope with these new technologies with the existing legal framework. And the existing legal framework, in this case, probably the most two relevant pieces of legislation are the General Data Protection Regulation and the incoming Artificial Intelligence Act. So this is exactly what I'm trying to study and what I'm actually arguing in my paper. I'm trying to do a stress test to understand whether those two pieces of legislation would be enough in order to protect the fundamental rights which are endangered by the neurotechnologies. So starting from the General Data Protection Regulation, the GDPR, here surely it's applicable given that we are discussing about neural data. We have heard about this definition also by Professor Vera. And we have neural data, which are personal data in as much as they can bring to the identifiability of the data subject. There is a processing, because we are indeed, in a way, processing the signal in order to convey afterwards the possibility to bring movements in the metaverse. So the GDPR is fully applicable in this case. The good news is that in the GDPR there are surely great safeguards for us to protect from let's say, misuses of those technologies. One of these is Article 35, the necessity for the companies to put in place a data protection impact assessment. And some authors are going even further, saying that we should go even more towards a tailored-made data protection impact assessment, in this case, which would be named after mental data protection impact assessment. On the other hand, we might have also some glitches. Probably there are some loopholes in the GDPR generally, because as also yesterday it was mentioned that probably not all the neural data can be encompassed under Article 9 with the special safeguards provided by that article. So just a portion of the neural data would fall under that category. And in addition to this, of course, the GDPR was forked some years ago, and it was taking into consideration an environment, of course, like the internet, but it was not that immersive at that time as the metaverse. So especially the consent requirements were a little bit more static than the ones in which the person accessing the metaverse nowadays is faced with. So, do we need to revise the GDPR on the basis of these new neurotechnologies and the metaverse? Well, probably there might be some small glitches that small but big at the same time, that everybody agrees upon. Also a study which was released by the European Service and it was commissioned by the European Commission. And in that case it was kind of agreed that we should place all the neural data under Article 9. This is one first point. But we could go even a little bit further by probably started to think that we should insert a new legal basis just for the processing of the neural data. So also here food for thought. Moving now to, let's say, a brand new piece of legislation such as the Artificial Intelligence Act, which will need to be interpreted in these years, but we can already try to, let's say, argue and see if the basic of those acts are sufficient to, let's say, face this new phenomenon. Also in this case, Artificial Intelligence Act surely is applicable. And then there are some provisions which consider that if there is an inference of emotions, for example, in the employment context or in education by the use of these systems, then those uses are banned. But this means that if we use, let's say, the inference of emotion in a recreational setting like the metaverse, then we should consider the system as introducible on the market, even though it is an high-risk system, most likely, at that case. And also in this case, we have a good news, that is to say that there is an high compliance activity for the producer of this kind of technologies that should be put in place. And of course, those compliance requirements derives directly by the requirements set for the high-risk systems. So we have very interesting safeguards, such as the necessity to bring a powerful risk management system, provide technical documentation, and so on and so forth. But if already we see the very important requirement of the human oversight, I'm not that sure that this kind of technologies, which really are detecting the signal by the minute, so basically with the visor and with the neurotechnology embodied, we can make thousands of actions just in 1 minute, then I'm not that sure that human oversight there could be always be guaranteed. More than that, if I can infer the motions, then in the future probably it will be possible also to infer sensitive traits like racial origin and so on and so forth. So to cut the long story short, also in this case, probably we already have to think that some adjustments to the AI Act probably may be needed. For example, the insertion of the neurotechnologies in, let's say, the Annex 3, considering the high-risk systems. But, and here probably I have a good news also for your institution and for the Metaverse Cathedral. There are already some authors which are thinking that, let's say, shortly it will be necessary to introduce also a Neuro Act, Artificial Intelligence Act. And of course, in that case, we will need many conferences like this one to delve even more into that topic. So I'm going to the conclusions. Of course, metaverse and neurotechnologies and brain-computer interfaces, it is absolutely a promising technology which could really bring to the next step the metaverse. On the other hand, they raise a serious concern, and we should look and we should continue to monitor the evolution of the technologies in order to see that the fundamental rights are always protected within, let's say, our beautiful European Union and hopefully also beyond. Thank you very much for your attention.
Well, thank you very much, Jacopo, for your presentation and for such insightful proposals. Considering the recent tendencies of the legislature, I don't know if they will be welcome or whether Mario Draghi will agree with you, but luckily he's not in the audience neither today. So now we open the floor for questions. Do we have, in the audience? So.
First of all, congratulations for the very thought-provoking presentations. I have actually two questions, one for Jaime and the other one for Kęstutis, is the name? Yeah. For Jaime, you've mentioned that these data spaces like kind of mitigate ex ante all the sort of problems with jurisdiction and choice of law. But what if one of the members of that data space company is located outside the European Union, where the rules are different? If that, let's say, a company providing cloud systems breach the agreement, then we will have the problem again, right?
Yeah.
Yes. The main example we have in data spaces related to this is the Catena X, that has attributed the competence to the German courts. So I think it's need to be attributed in the governance documents and the rule books. So ex ante we have to take care of this. So yes, it's a good question, but now I think it's still we are researching about it, and it's not so clear. But yes, I think it's a good point.
Okay, thank you. And the other one, I'm abusing the time, but okay. It's regarding the human-like virtual agents. When you were speaking about human and we should respect these figures, what's a human in the first place? And second of all, how would you set the boundary of virtual or human-like agents in the looking at how they look or how they behave? Because in the metaverse we see like avatars which do not have a human figure, and it is proven that, for example, in educational environments, like cartoon-like avatars work better. So where would you set the boundary as what's human-like and what's not human-like?
Yeah, it's a tough question. I would say it's a spectrum. I haven't tried to develop a full account yet of what counts as human likeness, but intuitively, let's just say one aspect definitely is the appearance. Another one is the interactive capacities, and third one would be how much autonomy the virtual agent has. So I don't know to what extent this answers your question, but I don't have a full account yet. So for now, it's more about ethical intuitions. We take an extreme example of an AI agent within the metaverse or virtual reality that is extremely human-like, and then we ask what are our moral intuitions about various ways of treating that kind of entity.
No more questions? Okay, so, well, then I have bad news and good news for you. Let's start with the bad news. We're still 1 hour away from lunch, but the good news is that hour is going to be filled by the presentation of the white book and the implementation of digital rights in the metaverse. Right before that, we're going to take a really small 5 minutes break, and then I will please ask you to be right back so we can continue, okay? Thank you very much to all the participants and to the audience for the attention and the questions.